My name is Mary Greer, and I'm the Senior Criminal Law Advisor here at the Rule of Law Initiative at the ABA. I was formerly employed by the Coalition for International Justice and was posted at the War Crimes Tribunal for the former Yugoslavia, and some of our CIJ colleagues are here as well. The Rule of Law Initiative is the successor to the organization formerly known as SEALI, which some of you are probably more familiar with. But the Rule of Law Initiative is about 3 years old, and we provide technical legal assistance in emerging democracies all over the world. In now, I think, over 40 countries. And most notably, we've provided technical legal assistance in some of the post-conflict countries that we'll be talking about today: Bosnia, Serbia, Kosovo, Sierra Leone, and now the Democratic Republic of Congo. We have a dynamic panel today. We had a last-minute cancellation by our colleague and friend Diane Orlicher. She mentioned the White House, so I'm believing her that she actually did have a conflict. But we're going to miss her in her discussion as well. We've got some of the publications that she and the War Crimes Research Office, as I understand it, sponsored by OSJI, published looking at the impact of the War Crimes Tribunals on Serbia and Bosnia. And they're great reads. They're on their website, but we also have hard copies out there. So we're really going to miss her discussion. But we have on our panel Judge Pat Wald, who was on the International Court for the former Yugoslavia. And I happened to get to cross paths with her there. Formerly, she was the chief judge of the DC Circuit. Thank you. She also sat on the panel of the Krstić trial, which was the first trial at the ICTY to address charges of genocide. Also on our panel is Judith Armatta, who's an author and a human rights advocate and a journalist, who was my successor in CIJ, and she had, as has been written on her book, she had a front row seat and monitored every day of the Milosevic trial. And the book that emanated from that experience is called Twilight of Impunity, the War Crimes Trial of Slobodan Milosevic. It's a well-reviewed book. I just got an email yesterday from a colleague who was posted with Opdat in Serbia, and his comments were, "I just finished reading Twilight of Impunity, and I have to say it's one of the finest books of any kind I've ever read. Not only is it a clear, readable account of the trial, but it's the best description of the events leading to the dissolution of Yugoslavia that I've ever come across. And this month, you've also been noted by the Editors of Choice, which is one of the top publications for scholarly librarians, as an editor's pick. So congratulations, Judith." Also, we have my colleague and friend Natacha, who is the Deputy Director of our Africa Division. And she also is the DC-based manager of all of our projects in the Democratic Republic of Congo, where our focus is combating gender-based violence and mass atrocities. Her specialty is human rights and gender justice and labor rights. We want to take advantage of all of the expertise in this room in having this discussion today, and we're going to have a very informal format. What I'm going to do is kind of pose a couple questions to our panelists in kind of an Oprah-like fashion, although there will be no iPads under your chairs at the end of the discussion, unfortunately. But I'm gonna ask our panelists to focus on the judicial mechanisms to address atrocities based on their experience and publications. And then after maybe 2 or 3 rounds of questions that I pose, I'd very much welcome discussion from the experts that we also have gathered to be part of our audience. So please feel free to formulate questions in your head and ask our panelists as follow-ups. Those of you that have already gotten refreshments, please feel free to refresh your cups, and the restrooms are out this door where Jeanette is standing, and then kind of over in that direction. You can tell that we do have media representatives in the room, and so tailor your comments accordingly. I also, before I forget to do this, I want to thank my colleagues at the Rule of Law Initiative for helping. Jeanette, Jeremy, Yuftahi, and I'm not sure if Anita's in the room, but these things don't happen without a lot of details that are tended to. So with that, I think we'll start with some of the questions. And so I wanted to start with kind of a broad perspective at first, kind of setting the stage, and I wanted to try to at least address one of the first questions to Pat Wald. In your book, Tyrants on Trial, some of copies are out here in the front. You stated that these leader trials are inevitably destined to be the crown jewels or the fatal flaws in the international court system, and it's necessary to the intelligent evolution of that system that we glean from the mistakes and the successes of the past how to run them better. And so, Judge Wald, do you have an opinion as to the overall contribution so far of the international courts and the hybrid courts in the progression of international justice?
Well,
and maybe highlight some of the
I do, Mary. I wouldn't be here if I didn't. Let me make just a few very brief points, hoping it will open up the discussion. One, I think that the international and the hybrid courts have in general made a tremendous contribution to international criminal law, and especially, obviously, international humanitarian law. And that's because of a couple of things. The first is that for the first time, certainly since Nuremberg, they have fleshed out with on-the-ground applications to a variety of particular situations, those kind of general doctrines of international law which you read about in the treatises, or sometimes even in the diplomatic documents, or sometimes in the sometimes obtuse languages of treaties. But they have done what judicial processes have always done in our domestic system and otherwise, and that's to take language which very often is open to many kinds of interpretations and apply it, flesh it out, and apply it to specific real situations that actually happen. And I think that in doing that, it has taken a tremendous step in developing international criminal law. But secondly, and on a slightly more conceptual plane, most international law experts, and I am not one, I have to tell you that before I went over to The Hague, my sole contact with international law had been I once met Ralph Lemkin at Yale Law School, but I didn't take his course because I didn't think it was going to be relevant to my future. But actually, there seems to be a consensus that generally international law was based on a national sovereignty system. There were obviously people at the Yale School and various other schools that disputed that. Louis Henkin, who came up with the notion that with the coming of the new century and the whole doctrine of human rights would eventually triumph the notion of national sovereignty as the basic lodestone of international law. And you still have a lot of people who are pushing for that, and I think the international courts are in a sense forwarding that. But again, it's the notion that if you have an agreement between nations that there are some rights which transcend the national sovereignty or the wishes of the national country that might normally be expected to implement those rights, that they have a place to be enforced, because a concept of human rights-based international law isn't going to take us very far unless there are agreed upon things, violations of international law. There's a consensus on the process for establishing what are violations and what are not. And finally, there are places where you can actually go to implement those. So those are my basic notions in the positive contributions of the international courts. Now, I'm not blind to the fact that they have had deficiencies, and I think our conversations and certainly Judith's book draws attention to these, and perhaps they've come most visibly in the leader trials. I'll just mention a couple of them, but obviously in her book and with specific relevance to the Milosevic trial, those will become clear. But I think in my own experience too, and I think some of this is being borne out in the ICC, which, as you all know, will probably become the flagship of international law, certainly of international law in judicial execution, because the ICTY where Milosevic was tried, the ICTR, Sierra Leone court, Cambodia court, I think eventually the Lebanon court, are temporary courts which are scheduled to go out of existence in a few years. They might be replaced by other ad hoc courts to meet particular emergencies, but the ICC, to which we are not a party, but that's a whole different subject, will be the permanent one, is likely to have the most influence on the jurisdiction. But already some of the problems of the ad hoc courts are beginning to arise there. One is, I think most of the courts have shown they can give you fair trials. At least it was my impression that the ICT, in fact, if anything, they were a little pro-defendant. But the problem is, can they give us efficient trials? I mean, and that seems to be the major criticism of the press in the United States. I mean, the ICC, it's been there 8 years. They've only got 3 trials in process, taking long. Everything's going back and forth. So the question is, can they be both fair and efficient? The second problem, which arises not in the Milosevic trial but in other leader trials, is how is it possible sometimes to try leaders who are still in power in the countries, like al-Bashir in northern Sudan? Nuremberg, they were all sitting in the dock. They'd all been captured. The war was over. Even Milosevic had been, in a sense, deposed in his own country. But people like al-Bashir in the Sudan, some of the leaders in Uganda, some of the other cases deal with people whom the diplomatic corps of various countries think they need in terms of the peace processes. So how do you deal with that? Okay, I think I've talked enough to open up the conversation.
Definitely. Either of you two ladies want to follow?
I agree with everything she said. Maybe just to talk a little bit about how remarkable it really is that, taken from Nuremberg, the place that we are today, take out the 50 years of the Cold War, but I think it's been a remarkable step. The difficulty sometimes is that people expect then that you have a perfect system, and that everything should and will work well, and if it doesn't, get rid of it. And of course, we don't have a perfect system. It's brand new. You know, the Nuremberg and the Tokyo tribunals were different. They were military tribunals. So we're working in a whole different environment at this point. Obviously, you can draw on those, and the courts have and will continue to do that. But this is a different day, and these are different situations. And these courts are, where do they get their justification from? Where do they get their legality? Well, from the United Nations, from agreement among the states, really. That's the other sort of remarkable thing, is that states have given up some of their sovereignty, especially when you see it with the ICC. I don't know how many now have signed and ratified the ICC, but
115.
It's 115. There you go. That's a lot, to give up your sovereignty, and some of your sovereignty. Now, obviously, there are some larger states that have a lot of influence that are missing from that, and that is a drawback of where we are right now. But we're at an early stage, and it's important to remember that, and to remember that when you're thinking of where we're going to be going. The other thing is that the international courts have had an influence on domestic courts. I think that it's been, one of the things they do is it's important to reestablish rule of law, especially in countries that are transitioning from a conflict. To see that an international legal system, to see how that works and to be involved in that is important for what happens domestically. And the domestic courts that have grown up in former Yugoslavia, with which I'm more familiar, they've drawn on the jurisprudence of the ICTY, and they've also received training and assistance from prosecutors and judges at the ICTY and Defense Counsel. So, that has really, I think, been an impact on societies that have been operating for a long time under the rule of men and not the rule of law.